Colleagues, first I'd like to preview the roadmap for today's hearing and clarify a few items. First of all, I'm going to give a few brief remarks, then we'll have an informational presentation by the city attorney and the chief of police. Then we'll have some council discussion where I'll offer a substitute ordinance. The substitute ordinance, I will ask my colleagues at the end of the session to vote for, but I want to be very clear. By voting for the substitute ordinance, all they are agreeing to do is put the ordinance on the table for discussion. So it may be that a colleague would choose ultimately not to support this legislation, this ordinance, but I will ask them to vote aye to put the substitute ordinance on the table for further discussion. The substitute ordinance, which was released yesterday, includes some proposed revisions based on input from my colleagues as well as others in the community. I'll ask my fellow commissioners who have any amendments to put those amendments on the table. We will then hear invited testimony. After invited testimony, we'll hear public testimony. Due to concerns about quorum and scheduling at 5 p.m., I'll ask the council to discuss and vote on the substitute ordinance. And again, that means just putting it into the record as the ordinance under discussion. And I will ask them to vote on the amendments. We will not be voting on the overall ordinance today. We've heard from a number of my colleagues who'd like to have time to reflect, to offer input based on any public testimony. So we will not be voting today. We will be moving it to second reading. We do plan on voting, as I said, on the substitute amendments, and we'll vote on them towards the end of the hearing before we lose the quorum. There will probably be a lot of people who would like to give public testimony. We will be losing at least one member of the council who has an important community event this evening. I will certainly stay, and if we have two other folks who are staying to keep the quorum, we'll keep taking public testimony. So with regard to my introductory remarks, I want to start off by stating the obvious. Portland is a vibrant, livable, and economically prosperous community. It's viewed that way by the rest of the nation, but it's also true that in recent months, we've become something of a magnet for folks who are either coming from outside the community or elsewhere with either a history of or an express intent to come to our community to commit acts of violence. Demonstrations have been increasing in frequency, and unfortunately, they've also been increasing in terms of the violence that we're seeing. This creates a danger to the demonstrators, it creates a danger to bystanders, and it increases the likelihood of risk to public property. It's also unfortunate that our city has gained national recognition for these increasingly frequent instances. It's bad for the reputation of the city and the brand of the city. There's no question that it has the potential to create a negative impact on travel and tourism and the economy overall. But I think more importantly, it makes people feel less safe in the community. I want to be clear that I understand that this ordinance is not a panacea to this issue. This ordinance would provide one more tool, along with enforcing existing laws, along with setting clear expectations about what is and what is not acceptable, along with helping to educate folks on how they can come and express their First Amendment rights freely and fully and remain safe at the end of the day. The major objection to this ordinance has been, at least what I've heard so far, is that we should enforce the laws that already exist on the books. I want to be clear. I agree with that completely. No. And we should also, as I say, continue to educate the public and establish clear expectations. These demonstrations, I believe that we've seen, and this is just my personal opinion, are a reflection of the national dialogue that are playing out on our streets. Our response as a city and as a community serves as something of a Rorschach test on what our city values. And let's be clear, I hope all of us today can agree that we value expression and dialogue and that we reject violence. Much of the opposition that I've heard to this ordinance is reflective of the national dialogue that I just referenced. Some people believe that the ordinance goes too far and could potentially curtail First Amendment rights. That's certainly not my intention. Others have expressed concern that this ordinance doesn't go far enough in addressing the increasing presence of the alt-right in Portland specifically. As a city, we have not had all of the necessary conversations around race that are reflective in our values as a welcoming, inclusive, and sanctuary city. And that is certainly factored into this conversation as well. So that's a long way of saying I believe it's important that we acknowledge the context in which I'm introducing this proposed legislation. But understand that whatever we do to address the behavior has to be content neutral in order to be constitutional. This ordinance is not about ideology or speech. This is about public safety and preserving the right of peaceful demonstrators to assemble. What about the constitutionality? And I know there's a lot of questions about this. Freedom of speech and association are amongst the fundamental rights guaranteed and protected by the United States and the state of Oregon's constitutions. The City Council enthusiastically supports the exercise of these fundamental rights. The law also recognizes the need for reasonable, content-neutral time, place, and manner regulations to ensure that speech and assembly rights can be exercised safely and without significant disruption to the rights of other members of the public. For example, the United States Supreme Court has explained, quote, that even in a public forum, the government may impose reasonable restrictions on the time, place, or manner of protected speech, provided the restrictions are justified without reference to the content of the regulated speech, that they are narrowly tailored to serve a significant governmental interest, and that they leave open ample alternative channels for communication and information. Applying the Supreme Court standard, the Ninth Circuit Court of Appeals has upheld time, place, and manner regulations for demonstrations. As the Ninth Circuit Court explained, quote, no one could seriously dispute that the government has a significant interest in maintaining public order. Indeed, this is a core duty that the government owes its citizens. Further, once multiple instances of violence erupt with a breakdown in social order, the city must act vigorously and more extensively to restore order for all of its residents and visitors. Adding large numbers of police on the street might be the solution in some cases, but in other cases could lead to more intense violence. As the Ninth Circuit Court reasoned, quote, we do not think that even the most vital First Amendment expressions can be said automatically to overcome the need of a city to maintain order and security for its residents and visitors in the face of violence, unquote. Similarly, under the Oregon Constitution's Article 1, Section 8, the Oregon Supreme Court has held that, quote, some burdens on expressive activities are permissible, such as time, place, and manner restrictions. As mayor, it's expected that I will do everything I can to uphold the public safety. We cannot deny the increasing rate of demonstrations and increasing violence. This ordinance seeks to remove violence from demonstrations and preserve the public's right to express speech meaningfully. This ordinance enacts reasonable, content-neutral time, place, and manner regulations for demonstrations held in the city with the goals of protecting both freedom of expression for demonstrators and the safety of the entire community. This ordinance does not apply for any demonstrations for which a permit has been issued. What this ordinance functionally does is give us the ability to take preventative steps to ensure public safety by setting the rules of the road when we have advanced knowledge and we have stated what that advanced knowledge is that leads us to believe that there is a significant threat of violence. Jurisdictions around the country have similar protections.
They're just not doing their job.
There are some basic ideals that we should be able to agree on as Americans. We don't tolerate violence in our streets.
No kidding.
Violence is not and has never been a legitimate means to a political end. I will not allow continued planned street violence between rival factions to take place in Portland, Oregon. And so with that, I'd like to turn it over to our city attorney and the chief of police. Thank you for being here.
Thank you, Mayor, members of council. My name is Robert Taylor. I'm Chief Deputy City Attorney. I would like to discuss just three things briefly, and then I'd be happy to answer your questions. The first is the purpose of this ordinance. And the purpose is to give the police commissioner a tool to issue time, place, manner regulations over demonstrations and counter demonstrations in the city when there are facts to make us believe that violence is likely. The main goal is to provide peaceful demonstrators and counter demonstrators the rules in advance. It has become clear, based on past demonstrations, that it's very difficult to manage these crowds on the fly the day of the event. And where we know that these are coming and we can plan in advance, this allows the police commissioner to let peaceful people know what the rules are so they can act accordingly. And then the police can focus their limited resources on those who are intent on not following those rules. This ordinance certainly assumes that if we give Portlanders the rules in advance, that they will follow those rules. And we are hopeful that this will give the police a tool, and the commissioner will, or the police chief will speak about this, an additional tool to help manage these demonstrations with the goal of reducing violence, increasing peaceful demonstrations, reducing arrests, and reducing lawsuits. The second thing I wanted to talk about is how it would work.
Exactly what it's about.
There has been, there are two main parts of this policy in the ordinance. The first is in the directive talking about the criteria where the police commissioner could issue these written orders. And those criteria are: there must be a history of violence between groups, and the safety of participants and bystanders is at risk. And third, there is a substantial likelihood of violence based on statements or conduct of those groups indicating an intent to do violence or other credible information from law enforcement.
And I just note for the record, Mayor, that the city attorney has just set forth a standard that is in your substitute that was not in the ordinance originally filed. So, and the key that I see on page, for those of you following this at home, on page 5 of the original ordinance, paragraph 10C, the sub-provisions 1, 2, 3 used to say or, meaning any one of the three would be sufficient. And based on your presentation and the substitute the mayor is going to offer, just want to be clear that it now says and, meaning they are all three necessary conditions that must be met. Is that correct?
Absolutely, Commissioner Fish. Thank you for pointing that out. And that's an important change between the ordinance that was filed and the ordinance as presented in the substitute. When there were ors in the ordinance, it did provide more flexibility for the police commissioner to respond to different situations. But there was a concern about wanting to clearly limit the authority of the police commissioner and make it clear that it could only be used if all three of those criteria were met. And that change has been made in the substitute. So now you need all three of those. The history of violence, the safety of participants is at risk, and a substantial likelihood of violence based on facts you know. That's a very important change. And then the other part of this ordinance is the requirement that the police commissioner issue written orders in advance. And that's important for a couple of different reasons. The first, practically, is it gives advance notice to the public about what the rules are for the demonstrations. It can be very difficult for police and demonstrators to try to manage the rules the day of. We've heard folks say that it's difficult for them to understand orders that are given by the police, by the loudspeakers the day of, and it's hard to know the right place to go if you're trying to be there to demonstrate or counter-demonstrate peacefully. This would allow the police commissioners to let people know the rules of the road in advance in writing.
Should already know the rules.
The second important part of the written orders is it would require the police commissioner to state factually in writing how those three criteria that we talked about are met. So this doesn't just leave it to the police commissioner to say, I'm going to issue these orders based on no facts. He's got to affirmatively state in writing how all three of those criteria are met. And that's important, particularly because courts have said when you're evaluating these types of time, place, manner restrictions, that type of written record is very important for the court to review. And without a written record, courts are very concerned that a public official might be using unfettered discretion. But by requiring those written orders in advance to satisfy those three criteria, the court can better evaluate whether those time, place, manner restrictions were reasonable. There's further limitations on what can be in the written order, and they're spelled out in the ordinance. Another example of that is how the demonstrators and counter demonstrators can be redirected, and I would point you to section D3, directive D3, and this is an important point, where any such redirection shall be to a location that is reasonably close to, sufficiently approximates, or reaches substantially the same audience as the original location. So, and that's another important principle that you get from the case law, that sometimes the location of a chosen demonstration is important for the message. And so if the government is going to issue time, place, manner regulations and redirect demonstrators and counter demonstrators, it needs to be reasonably close to where they want to be so they can reach the reasonable, substantially the same intended audience. The last thing I want to just talk about briefly are some of the further checks on the police commissioner's authority in this. The first, by requiring the written orders in advance, it allows the public to evaluate the reasonableness of the use of this discretion and the reasonableness of the restrictions. And by having a police commissioner, an elected official, issue those written orders, it allows for some public accountability there. So they can judge the use of the discretion in the written order, and they can hold a public official accountable. Also, like I mentioned before, the written orders allows a court to review these in advance if they're challenged. so the court can see at the time when these decisions were made what the factual basis was. Third, there's a provision in the ordinance that has been added since it was originally released a couple of weeks ago that would require the police commissioner to report back to council within 30 days after using this authority. So the council would get to hear the lessons learned, would get to evaluate whether the authority was used properly. And then the final provision is there's a sunset provision that currently would have this ordinance sunset at the end of 2019. So if it works and it's a useful tool, the council can vote to continue it. If not, it expires.
Robert, if I could add one more to the list, which you diplomatically left off the list. As the order would be issued by the police commissioner, in this case me, that also subjects the police commissioner to potential lawsuits, which means the police commissioner can be deposed. And therefore, there's an incentive for the police commissioner to be very judicious in the use of this tool and use it in a limited manner.
Yes, sir.
In my opinion.
Yes, sir. That's part of the
Been
public.
deposed recently.
That's part of the public accountability and the accountability through the court system.
Does that complete your presentation? Yes. Very good. Chief Outlaw, thank you.
Thank you. Good afternoon. Thank you for having me and allowing me to provide some information from the police perspective today regarding this very important ordinance. First, I think it's important to acknowledge the many protests and demonstrations, marches and events that's occurred over many years here in Portland. And a lot of those have ended with little to no incident. They've been peaceful, and those are the ones that don't make the news. But I want to acknowledge what's going on right now. I've seen some narrative out there flat out stating that Chief Outlaw just wants more power. This is not about me. Me taking this job is not about me. Violent protests are not solely a Chief Outlaw concern or a Mayor Wheeler or a Police Commissioner Wheeler concern. In fact, violent clashes between demonstrators in Portland have existed long before the two of us took positions here in Portland. However, recently we have seen an increasing number of violent protests where various groups come together for the purpose of fighting or committing violence. This is a community concern. We have received numerous phone calls and emails from the community, and I acknowledge their frustration of not being able to move about the city, not being able to get home, pick up their kids, or get to work in a timely manner during violent protests. But not only have I heard from these community members, I've heard from other people who aren't even from here, who are fearful to come downtown. I've also heard from those who identify as activists who want to peacefully protest about certain issues, but have been silenced from others. Others who use fear tactics when it's believed that their ideologies did not align with theirs. As such, these activists fear for their safety amongst those who come together for the purpose of fighting or committing violence. And instead of them coming to exercise their First Amendment right to free speech, they stay home. The community is fed up, and they no longer want to see our beautiful city seen as a place to be disrespected by violence and lack of care and consideration to those who wish to exist safely and without threat, whether physically or fiscally, to their livelihoods. We want to make this a safe environment for everyone. And as the police commissioner, Mayor Wheeler, referenced earlier, the Ninth Circuit has said, adding large numbers of police on the street might be the solution in some cases, but in other cases could lead to more intense violence. And I agree. Adding more police to respond to violent protests is not always the answer. I've also heard why should we give you another tool when you don't use the tools that you have? I will begin by stating that the question in and of itself isn't completely factual, and I'll tell you why momentarily. But my immediate response to that is, why not? I believe we all share the same goals. We want to ensure that everyone has the right to safely exercise their First Amendment right to free speech. We want demonstrations to conclude without injuries to anyone involved or anyone in the immediate area. We want demonstrations to conclude without damage of property or infrastructure. But most importantly, we also want all of this to happen without the use of any force necessary by the Portland Police Bureau. When it comes to crowd management, there is no one set defined tool for any one demonstration, and there are no cookie cutter responses. The more tools we have to utilize in our tool belt to address violent demonstrations will allow us to be more strategic and proactive in preventing violence before it begins. Furthermore, a response relying solely upon arrests during violent demonstrations is reactive, and it increases the likelihood that force by the PPB will be used. If we continue to focus solely upon arrests, we are not addressing the root cause of the issue at hand, and we are too late because the violence has already begun. The existing tools only allow police, when possible or feasible, to address violence after it occurs. Over time, including prior to my arrival 1 year ago, we have utilized the tools and laws available to us during violent demonstrations. This has resulted in arrests, uses of force to cease the violence, lawsuits, increased violence between groups, and even on one occasion, 200 officers on a skirmish line. We've also tried a hands-off approach when our presence exacerbated the situation and have sought to identify and arrest individuals after the incident. Let me tell you how we currently manage protests. When we learn about an upcoming protest or a demonstration, the Police Bureau members attempt to communicate with event planners, and we even assign police liaisons. The groups often do not usually respond to our concerns about safety or security. We then develop a plan, coordinating our responses with the resources that we have. However, this is difficult when we don't know when and where groups of people will march. The Police Bureau has expended considerable resources in past events trying to ensure that these groups remain a safe distance apart. For example, during the August 4th protest, it required more than 200 officers, as well as mutual aid by other agencies to respond. A critical component of this response meant that we had to redirect police resources during these demonstrations and were unable to answer 911 calls for service. We also had to call on neighboring law enforcement agencies who are also short-staffed to assist. Once these groups of people who have engaged in past violence come together, we don't know when and where they will engage in fights or assaultive behavior. It can be during a march, in the middle of a large crowd, or occur at a place where police cannot readily or easily respond. In addition, there can be challenges to get here. So I'm saying all of this to say we've utilized the tools that we've had for past demonstrations, and we've been innovating in our planning when we have the luxury of being able to plan in advance. Responses to calls for service to priority calls only. At times when possible and they're able, again, we've received assistance from outside agencies to assist us with these calls. Other community impacts include injuries, as we all know, to many. Not just to those that are involved in the protest, but to officers as well. I've already mentioned the fear and frustration in our community, and it also takes a huge toll on the well-being not only of our officers, but of community members as well. These costs, both tangible and intangible, are eroding the trust for which we are working so hard to establish and maintain between the community and the PPD. And this is the ultimate cost. So in closing, this new ordinance would not only provide the police with a proactive tool, but it allows us to get ahead of the issue before it starts. We were hired, we were brought forth to look at new, creative, innovative, and strategic ways of addressing an old problem. We've been doing the same thing and getting the same results. At what point do we look for new ways to come up with a different solution? I look forward to hearing the input from other stakeholders here today, and I really hope that we can move forward towards a resolution to solve this matter. Thank you for listening.
Thank you, Chief. Colleagues, any questions for this panel? Commissioner Daly and Commissioner Lewis, and then Commissioner Swanson.
I have a number of questions, but I'm gonna hold most of them for once we hear from all the panels. So this question is for City Attorney. What happened, okay, I need to set this up. So when Patriot Prayer plans a rally in our city, they're pretty good at walking the line of avoiding speech that would trigger preemptive action. But we do see numerous members or followers of their organization making explicit threats of violence on social media. So it's my understanding that because it's not the organizers making those threats, that there's nothing that we can do in advance. Is that accurate?
That is an accurate statement, and what the case law also tells us is.
Can I just make a
Yes.
request? This has been brought to our attention by some folks with disabilities. When we have answers to questions, could you, everyone identify themselves again, just so that folks in the audience who may have disability know who's speaking?
Thank you for the reminder. It's Robert Taylor, Chief Deputy City Attorney. The answer to your question, Commissioner Daly, is that's correct. And the other thing that the other principle that emerges from the case law is just because you have folks that have demonstrated in the past and it has led to violence, you can't restrict their right to demonstrate again in the city. And San Francisco tried that a number of years ago in response to some mass demonstrations where they effectively prohibited demonstrations in the entire city and county of San Francisco. And the Ninth Circuit struck that down. So part of what this ordinance is trying to accomplish is to recognize and respect the First Amendment rights of demonstrators and counter-demonstrators, to let them come and exercise their rights, but to do so in a safe way that's safe for everybody.
Okay, so here's my real question.